James, what happens to earnest money funds once we go under contract? Okay, so earnest money is going to get deposited into a trust account that's managed by a neutral third party. Typically that's either a title company or a real estate brokerage. By law, it has to get deposited into a trust account in a short period of time and make sure those funds are held there. The purpose of that is to ensure that those funds are secured and not available to either the buyer or the seller until certain conditions of the contract are met. Remember that the purchase agreement has contingencies in it, okay? And the buyer gets to use those earnest money funds at their closing for their down payment or their deposit as long as contingencies are met. Now, if the buyer does not meet certain contingencies, those earnest money funds could be gone. They could be given back to the seller as kind of a penalty for the buyer not meeting their terms of their agreement. In the rare case that there is a dispute between the buyer and the seller and they cannot come to terms on it, typically we see something rectified there. But in the rare case, that typically what happens, it either goes to arbitration, if that's what the parties have already previously agreed to, or it can go to court, whether small claims court or court, and then it can get hashed out there. In 10 years of doing this, I've never seen that happen. I've heard of it, but personally with our clients, we've never had to do that, either arbitration or go into court. But it is very important that if you are a buyer, you make sure that you are hitting all of your deadlines and your contingencies, and as a seller, you're keeping a close eye on the transaction, you know where things stand, leaning on your agent to help you with that process. So that's what happens with earnest money through the escrow process.